All right, we've got some answers now for your legal questions. We're going to turn to our Fox 26 senior legal analyst, Chris Tritico. Great to have you with us. Happy holidays. Thanks for being here.
Good to be here.
Let's dive right in. Bill writes to us, I live in a privately owned apartment complex with partial assigned parking. Some residents pay a premium for dedicated spaces with unassigned spaces available to anyone. The number of spaces for handicap meets requirements. Another resident and I were accommodated with a handicapped space until a new handicapped resident moved in. 2 spaces for 3 handicapped residents causes a problem. Adjacent to the handicapped spaces, 10 spaces are dedicated, premium numbered spots not available for us to use. As the premium spaces increase, the handicapped spaces do not. I talked with the apartment management, requested an additional handicapped space. They said they have the required number of spaces, but none of the residents with reserved spaces are willing to give one up. So what are my options for a handicapped parking spot? My declining health is challenging my mobility. I am bound by a lease agreement for the next 10 months that I can't afford to break due to penalties. What are the manager's responsibilities? Great question.
It is a good question. Now, assuming that they meet the required number of handicapped spaces for the amount of residents that live there, and you should check this out with the city because 2 does not sound like it's enough to me. Yeah. But assuming they meet that number, they do not have to add any additional ones. It's a revenue source for them to lease those spaces to people as premium spots. So if 2 is the minimum number they have to have for the number of residents in the apartment complex, they don't have to do anything. But again, I question whether that's enough for the number of residents that live at the apartment complex. Call the City of Houston, call 311, or find out who your city council person is and call that office and ask them to check it out for you. Because if they don't have enough, you can force them to add one.
Okay.
Good luck.
Yeah, let's dive into our next question. It comes from Shelley, who writes, she stored all of her home furniture and appliances in a climate-controlled storage facility. Approximately a year later, all her belongings were damaged with mold. She filed a claim with her renter's insurance and the storage facility, only to be denied by both, stating they don't cover mold and mildew. At the very least, she feels the storage facility should be liable. The reason she paid that extra to store her belongings there was to have them in that climate-controlled facility. The facility and insurance admit that it was an AC malfunction, but no evidence of a covered water intrusion. Therefore, the denied claim, because of the policy, is named as a peril policy. She spoke to a regional manager after receiving the denial letter and was told after speaking with their president, the most they could do was offer a credit for 1 month. What can I do?
What you can do is contact either the lawyer of your choice or file suit in JP court, but I recommend going with the lawyer of your choice because they're getting you on the verbiage here and trying to get out of this. It's not a peril, it's not water. It's the fact that their AC malfunctioned and it allowed humidity to build up inside the unit, and that's what allowed the mold to grow. It's not that water came in, it's humidity built up and the mold grew because their AC malfunctioned, and you leased a unit with AC. They breached their contract with you, okay? So you're entitled to them replacing your damaged goods. Get a value on what you lost and sue them for breach of contract and under the Texas Deceptive Trade Practices Act. You're entitled to attorney's fees on both. Contact the lawyer of your choice and see if you can get them to help you. It's not a big damage claim, so you may have a hard time finding a lawyer, but you do have a claim. Good luck.
All right, well, our final question comes from Sherelle, who writes, I live in Harris County, just outside the Houston city limits. My subdivision has an HOA. My neighbor has 8 dogs, one of which is an aggressive pit bull. They bark all night, they tear up the fence, they dig holes, they come into her backyard and trample her garden. The neighbor replaced the boards that they destroyed, but nothing seems to stop them from barking all night or digging. She says she has sent her 3 certified letters regarding the barking. She sent me a text claiming that I was harassing her. She now has 3 new puppies that seem to be hoarding dogs. I have not seen anything in our deed restrictions regarding pets. I'm restless, frustrated, and tired of fixing the fence. She's not approachable. She literally leaves when she sees me coming. What can I do?
Well, HOAs rarely get involved in dog issues, and so I'm not surprised that they're not helping you. What you have here is what's called a public nuisance. And with the dogs doing what they're doing and she's not going to take care of her dogs, then you can make a claim against her for a public nuisance and have a court enjoin her and force her through a court order to do something about this public nuisance. You're going to have to hire a lawyer to do that, and so contact the Houston Bar Association to find someone who could help you. You may be able to get attorney's fees for that. I don't remember if you can or you can't, but you're going to have to hire a lawyer of your choice to do that, but you can file suit and you can get an injunction for that. Good luck.
All right, Chris Tritico, thanks so much for being with us. Great questions, great answers. Thanks for that today. And if you want to send us your legal questions, just hop on our website, fox26houston.com. You can find Chris's segments under the Morning News tab. And as always, for specific information and advice, contact an attorney of your choice. Chelsea.